rules for 2019. These are add-on questions. This is Supreme and County Court only. The Uniform Rules Part 202 for 2019. Uniform Rules Part 202 for Supreme and County Court, Civil. 51. These are new for 2019. Question. The clerk shall refuse to accept for filing a paper when? And the answer to this question, it was A, all of the above, and I'm going to go through all of these so that you can memorize them. 1. The paper does not have an index number. 2. The summons, complaint, petition, or judgment contains an et al. Or otherwise does not include a full caption. The paper sought to be filed with the county clerk is filed in the wrong court. So I guess that's saying that if they come to the wrong court, we're supposed to forward it to the correct court because we're not the county clerk, but the county clerk doesn't have to forward stuff. They were just supposed to not accept it. The paper is not signed in accordance with the section 130-1-1-A of the rules of the fucking chief administrator. Okay, so part 130 of the rules of the fucking chief administrator is saying that an attorney, when he signs a paper in accordance with those rules, they're certifying that the paper is not frivolous. Signed in accordance with the law 130 of the fucking chief administrator. 5 is the paper sought to be filed as an e-filed action. It's not being electronically filed, and it's not being filed by a pro se person who is not participating in e-filing. Okay, the paper sought to be filed is in an action subject to electronic filing, is not being electronically filed, and does not include notice of hard copy submission required by Rule 202.5 B sub D. That was 6. 7. Whenever provided by court order, rule of the fucking chief administrator, or by statute. Now I'm going to go through these much quicker. So, when can shall the clerk refuse to accept a paper for filing? Paper not signed, paper in an e-filed action is not being electronically filed, not being filed by a pro se person, or is missing the notice of hard copy submission that's required by the rules, or whenever by court order, rule of the fucking chief administrator, or by statute. Rule 202.70. Now, they can ask a really easy question on this, like, what is the commercial division? Is it in the Supreme Court? Answer yes. Or what are the amounts? Like, it's usually 100,000. Some places it's 50,000. Or they can ask a really hard question, which is what I put on this quiz. Okay, so the answer to this question was E, none of the above. Provided the monetary threshold is met, cases that may be accepted in the commercial division include actions in which the principal claims involve or consist of which of any of the following. And none of these are on it. All of these are specifically, they're not allowed to be part of the commercial division. Fees, no. Real estate for rent, in judgment enforcement, declarative. There is a long list of stuff that is part of the commercial division. I suggest that you read it at least once. So I'm going to try to tell you what it is, including, and okay, there's 12 of them. Out of those 12, 4 of these do not require the monetary threshold. So I'm going to go through these the best I can. Hopefully this is an abbreviated list. So there's 12 things that it does include. And out of those 12, 1, 2, 3, 4 of them do not require the monetary threshold. So I'm going to go through the list of 12, and then I'll tell you which 4 don't require the monetary threshold. 1, breach, fraud, business torts arising out of business transactions, trade secrets, restrictive covenants, sales of assets or securities, but no discrimination employment contracts. Okay, so it's all that stuff minus discrimination employment contracts. 2, Uniform Commercial Code transactions except for co-ops or condominiums. 3, Commercial Real Property, Yellowstone injunctions, but does not include lawsuits over rent only. Okay? 4, Shareholder derivatives. No idea what that is, but shareholder derivatives. 5, Commercial class actions. And those 4 and 5, you can put a star next to those because those are 2 of the ones that don't require the monetary threshold. 6, business transactions with banks or other financial institutions. 7, internal affairs business transactions. 8, legal or accounting malpractice. 9, environmental insurance coverage. 3, commercial real property actions, including Yellowstone injunctions, but does not include actions where the dispute is over rent only. 4, shareholder derivative actions. 5, commercial class actions. 6, business transactions with banks and other financial institutions. 7, internal affairs business transactions. 8, accounting malpractice or legal malpractice. 9, environmental insurance coverage. 10, commercial insurance coverage. 11, dissolution of corporations, LLCs, partnerships. 12, stay or compel arbitration. You're the ones that are not included in this. And I'm wearing a red bow for stop, no commercial division for you. Okay? Suits to collect professional fees. Real estate disputes involving payment of rent only. Proceedings to enforce a judgment. Cases seeking declaratory judgment for insurance coverage for personal injury or property damage. Employment contracts about discrimination. Co-ops and condo transactions. And there's other ones, but I don't remember them all. You cannot go to the commercial division if you have one of these cases. And so I'm wearing red because red means stop. Okay. 53-202.70. Within 90 days after service of the complaint. So 90 days after service of the complaint, not the summons. It's 90 days after service of the complaint. A party may seek to have a case assigned to the commercial division by filing, I'm missing a word there, sorry, by filing a request for judicial intervention, so an RJI, that attaches a completed commercial division RJI addendum. So you have to file a regular RJI plus an addendum called a commercial division RJI addendum. And you must do that within 90 days of the complaint. 90 days of the service of the complaint. So 90 days after you serve the complaint. Okay, so I want to mention one thing because there was 2 rules questions on there that on my principal test that I challenged. It really pissed me off that the scores haven't come out yet and I haven't been able to see if I won those challenges. So I'm going to try to tell you what I remember about one of them. One of them was a 208 question and it was talking about commencing an action by e-filing. And they claimed that the correct answer was that it had to have the index number on paper. So I wrote a challenge saying, you dumb motherfuckers, you never even worked in a court. How would the attorney have the index number if he's purchasing the index number by commencing the action? But then I looked in the actual rule and they were taking it right out of the rule. So it did say index number on paper. The other one was something about 2 business days. Dorothy's going to do the video on that one. And then was on the principal exam, there were 13. Read what I just said. I counted at the review. I counted them. 13 family court rules questions. There were 2 New York City civil court rules questions. And I think